Hello, everyone, and we will get started. I'd like to welcome everybody here to this public lecture in the STL public lecture series. For those of you who are not familiar, STL is the short name of our law school, S School, T Transnational, L Law, Peking University School of Transnational Law. Welcome to everybody here and also to those who are joining us on Zoom. We're very privileged and honored today to have as our guest speaker, Virginia Harper Ho from the City University of Hong Kong, where she serves as professor of law and also the director of the Center for Public Affairs and Law. Professor Harper Ho's research interests are in corporate law, corporate governance, securities law and securities regulation, and also sustainability from a comparative perspective. And she also has interests broadly in comparative law and Chinese law as well. She's a research member of the European Corporate Governance Institute, or ECGI for short. And prior to joining the City University of Hong Kong faculty, Professor Harper Ho taught at the University of Kansas Law School in the United States, where she served as the Earl Schertz Professor of Law, and also served as Associate Dean for International and Comparative Law Programs. And today, Professor Harper Ho will speak to us on the topic of corporate climate governance, and she'll speak for about 30 to 40 minutes, after which we will open the floor for questions. I would like to now give the floor to Professor Harper Ho. Thank you.
Thank you so much, Norman, for that kind introduction, and thank you also to Dean Feldman and to the faculty and those who are here in person or on Zoom. It's a great pleasure for me to be here with you today on such a beautiful day here in Shenzhen. The last time I was here, I'm afraid to admit, it was nearly 15 years ago, and it's a great pleasure to be here on the eve of your next anniversary and to just really see what the school has become since I last had a chance to be here physically on the campus. So very pleased to be with you today. So the paper that I am presenting to you is a work in progress, and it is available on SSRN. I have a link a little bit later on if you are interested in it. For those of you who are colleagues in the room, it is a work in progress, so I very much am looking forward to the questions that you might have for me later this afternoon to help improve the paper as well. This is a corporate talk, as you can see from the title. It is about corporate governance. So if there are any in our audience today or on Zoom that are more coming at this from the climate perspective, maybe in an environmental expertise or interest, we will say a lot about that. But I will be referencing some of the scholarship in corporate governance that bears on this topic, and I'll try to be as accessible as possible. But if something is unclear, I do hope those of you in the audience or online will feel comfortable to raise a question, and I hope I can clarify. The other thing to say about this project is that it is intended for a US audience. So we are here at a school that where the students and faculty, again, are coming at our work from a US perspective. But the reason that I approached this from a US perspective was as a kind of challenge, because as many of you know, the US is not only probably one of the most influential jurisdictions in thinking, in terms of thinking and scholarship around corporate law and corporate governance, but it is unfortunately one of the jurisdictions in the world at present that is most backward with respect to climate progress and climate policy, at least moving in a much more measured pace. And so I think for that reason, I decided to target this project to speak to more of a US audience and a US academic audience. And so I'll try to tie it into things here as well. So this is what I'd like to, let's see if I can, I'm not sure I can advance the slides here. I'm having a little difficulty if someone might be able to fix this. Yeah, okay, there we go. Okay, so this is a bit of a roadmap for my remarks today. I'd first like to talk about a very long-standing debate in corporate law, which goes back literally 100 years, between kind of shareholderism or the primacy of shareholders and concern for the interest of stakeholders, broadly defined. And so there has been a kind of revival of stakeholderism in corporate governance debates among scholars in recent years, and I'll say a bit about that. And then I'd like to talk about the critique of that resurgence and that debate. And again, this has been a stronger debate in the US than here in Asia or in Europe, where from the outside, some of this might look a little bit quaint or outdated, but nonetheless, it's still very influential, again, because of the size of the US market and the leadership of US scholars in the academy in thinking about corporate governance. And then finally, I'll turn to the core topic for today, which is the question of this paper, which is what is the effect of international corporate climate and sustainability disclosure regimes that apply under capital markets regulation in most jurisdictions, in most capital markets worldwide today, or at least are coming online. And how does that affect, or how will that affect, how we define or understand good corporate governance? So that's kind of where I want to go today. So just to start out, for those of you that are may not be from the corporate governance field, here's a definition of corporate governance from the OECD, which most recently in 2023 revised its principles of corporate governance. And so we can think about corporate governance quite broadly as involving a set of relationships between a company's management, board, shareholders, and stakeholders. And the corporate governance also provides the structure through which the company is directed and its purpose or objectives are set, as well as the means for attaining those objectives and monitoring whether we're attaining them. So that's kind of a basic definition of corporate governance. There are a couple key indicators of good corporate governance that have emerged from a very deep and rich academic literature. And so I'm just simplifying here quite a bit. We could think of kind of three core indicators of good corporate governance. One is lowering agency costs. And that typically is thought of as the agency costs that might arise between directors who sit on the corporate board and other managers of the corporation and shareholders or investors. Okay. There's other agency costs as between majority and minority shareholders as well. So lowering those agency costs is a kind of indicator of good corporate governance. Secondly, strong shareholder rights. Okay, because if you provide strong protections to shareholders, others may be encouraged to invest. So that's another indicator of good corporate governance. And lastly, minority shareholder protection, which I mentioned a moment ago, because if minority shareholders are not protected, then only controlling positions in shares will have value. Again, that might dampen investment. But the idea is that these three things together, and maybe there's some others as well, have been shown in the empirical literature to be related to and contribute to higher financial performance. And that's typically how we determine whether they are in fact good indicators of good corporate governance, is whether they do lead to higher financial performance. And this has been an area of study for a really long time. I could put a lot more citations up here, but there's a deep literature on this. There's also a very deep literature at this point on the relationship between corporate governance and sustainability. And sustainability can be defined in many different ways. And as you might imagine, the research also chooses different ways to define sustainability. Some of these studies define it as corporate social responsibility. Some of these studies define it as environmental protection. Some of these studies define it as long-term versus short-term. There's a lot of ways to look at this. But the studies that I'm citing here on the slide are what we call meta-studies, or literature reviews that survey what is by now a very long field of research. And what we find is a couple things. There's much more we can say on this, but in brief, that corporate board capacity and expertise on sustainability also is connected somehow to board efficiency and can improve decision-making. So that's a finding from the literature. There is also, it appears, a kind of bi-directional relationship between internal measures of good governance and sustainability or social responsibility output. So and it's very hard to tease this out empirically, But the idea is if you are a sustainable or responsible company, you will have better good governance. You will have better corporate governance. Now, which is the chicken and which is the egg is where the research has challenges. But there is, it appears to be a kind of virtuous cycle that if you are well governed, you are likely to be more sustainable. And once you have a goal of being more sustainable or you seek to work in that direction, it requires you to put in place some good governance systems. Thirdly, the literature on board independence and diversity, so the characteristics of who sits on the board, suggest that those factors also contribute to better sustainability performance from the corporation. At the same time, there are many studies, and we'll talk more about the pushback on this, but there are studies that really highlight the challenges that corporate boards face in trade-offs among competing interests or competing stakeholders. This is not easy. This is something that boards and management do every single day, but there are trade-offs involved. There are real costs also in investing in sustainability. As critical as that investment may be, it is not free, okay? And therefore, there are some limits of what we might call the economic or the business case for social responsibility or for sustainability or for climate action, even if all of those things might contribute economic value as well. And one of the most recent studies I've highlighted up here, if anyone's interested later, I can provide a full citation, but there's a study by a number of scholars out of Germany that have been looking at whether there is economic or financial payoff to lower greenhouse gas emissions. And that's something we're all obviously very focused on. And prior studies had suggested that the costs were more short-term costs, but that if you looked over the long term, there would be long-term financial savings or benefits to lowering greenhouse gas emissions. And obviously this is very difficult to study. But this more recent research suggests that there might be costs both in the short term and in the long term, and I think that makes some sense. We can't expect this to be free, maybe even looking further out, and that's really what that study suggested. So there are some costs. Nonetheless, we've seen a revival of this kind of stakeholder focus within the academy and in also the public discourse in the US as well, which has led to a kind of backlash or pushback in the US that many of you may have heard about in the news, kind of anti-climate, anti-ESG. We just had an election. I'm from the US, so I say we as part of that policy. But anyway, we've all been watching that. But there has been within the academy and among corporate scholars a discussion of that brings stakeholders into corporate law in a new way. Concepts like enlightened shareholder value out of the UK, new corporate governance, Hart and Zingalis has some work on that, sustainable corporate governance, shareholder welfare, enlightened value maximization, responsible capitalism, a whole series of terms about this kind of intersection. And the reason this is a big deal is because from a theoretical standpoint, there is a long history in among US scholarship in particular, and in the UK to some extent, focusing very heavily on the important role of shareholders, and related to that, an idea that stakeholders really don't belong in corporate law at all. So bringing stakeholder interests into corporate law has been seen as kind of controversial, and there has been some active debate about it. Again, maybe outside of the US, this is not really as shocking as it might seem. But in any event, different jurisdictions approach this balance or this relationship between corporate performance and shareholders and stakeholders in different ways. And there are different variations, even among jurisdictions that might put shareholders first as a matter of law and might adopt a kind of clearer shareholder primacy perspective. So if we look at the UK, dating back now to 2006, the UK introduced something called enlightened shareholder value. There's been some recent cases in the Supreme Court of the UK that put the emphasis on shareholders, as the statute does. But nonetheless, this is a statute that says that while considering the success of the company and focusing on the success of the company and for the benefit of its members, that means the shareholders, the directors must have regard to a whole list of stakeholder interests, including employees, the environment, et cetera. Okay, so the question is, how far does this get us? Is this a radical change, or is this just business as usual? The Supreme Court seems to have taken a fairly conservative position on that question in the UK. Delaware, which is where a lot of corporate law is made in the US, has been historically ambivalent. And the reason for that ambivalence is that as a matter of corporate governance function and mechanisms, Delaware really isn't shareholder-centric, it's really director-centric. And there are some things that I've put in the box on the left-hand side, many of you may know, factors which make US law this way, and particularly the law of Delaware, which is the defining state law for most of our listed corporations. Directors are charged with management of the corporation. We have something called the business judgment rule. I know many of you in this room are well aware of it, which gives great deference. And for those on the stakeholder side, gives a lot of space to think about climate, to think about the environment, to think about employees. As well, it is almost impossible to sue directors for breach of their duty of care. I have since learned, since coming to Hong Kong and now teaching company law in Hong Kong, which is essentially UK company law, that the duty of care is much more robust in the UK and other common law jurisdictions outside of the US. And you are not allowed under UK or Hong Kong law, for that matter, to exculpate directors for breaches of the duty of care. But now you can do that not only for directors, but also for officers in Delaware. What does that mean? More space for discretion, more freedom of movement, and that can cut in many directions. That can give more space to think about climate and make decisions that are more long-term. It can also cut in the opposite direction. In addition, shareholder proposals in the United States, particularly in Delaware, are precatory or advisory. The board can say, okay, the shareholder majority voted in favor of us doing more on climate or us producing a climate report, but we can completely ignore it. There is no legal obligation for the board to listen to that. Now, of course, they can be kicked out at the next election, maybe. Okay, but maybe not, so they make that judgment. It's an advisory opinion or recommendation. Okay, not so in the UK and in some other jurisdictions, but in the US, there's a lot of space for boards to move. As a result, there is broad director discretion to consider stakeholder interest and impact. So there's kind of ambivalence within US law. And for many years, there's been some great thinking on this. Bainbridge and more recently, Chris Bruner have talked about this as the tension between purpose and process in the law. And I think this diagram is kind of helpful. If we think about what's the purpose of the corporation, and a lot of the debate I've been describing is about what is the purpose of the corporation? Is it only economic, or is it to make the world a better place, or both? The answer is it's kind of both, right? On the process dimension, which is this kind of a vertical dimension, we might call it the ends or the goal of corporations or corporate law. We could put shareholder wealth maximization, making the most money possible at the top. We could put only caring about stakeholders, maybe operating like a charity at the bottom. Okay, so there's that dimension. That's the purpose dimension. Okay. And Delaware's been pretty strong, and particularly recently, on doubling down on the purpose dimension, that your job is to maximize shareholder wealth, at least in some circumstances. Even there, Delaware law is a little ambivalent. But the process dimension is very much directors in the driver's seat, as we say, director's discretion. So there's this kind of ambivalence in Delaware. As I said, there's been a bit of doubling down. That means kind of going back to the beginning stage, or really reinforcing this position. And so if you look at one of the more interesting recent cases, this is a case from this past year in the Delaware Chancery Court by what we call a shareholder activist, who's very much a social responsibility advocate, suing Zuckerberg. You might recognize the name Zuckerberg, CEO of Meta, Facebook, et cetera. And the argument in this case was really around the question of what does it mean to put shareholders first? What are shareholder interests? And the argument that the plaintiff was trying to make is that today, shareholders are diversified investors. they own portfolios of companies. And there's been a lot of academic writing recently pointing out that when you are a diversified investor, if a company in your portfolio is polluting very heavily or is investing very heavily in old industries like oil and gas extraction, and you also have a portfolio that is, you hope, going to make money in the long term, and you have other companies that might be affected by that pollution or might be affected by the choices that these kind of less green companies are making, you might care about that as an investor. That might affect your portfolio. You might be looking at a portfolio perspective. You might be a common investor who's looking at the effect on the economy as a whole, not only at one firm's choices. You might be looking more broadly, and that kind of brings in stakeholders. That brings in the environment. That brings in climate risk, for example. And the court said, no, what we mean by shareholder interest is firm specific. And so if you look at the quote here, the court said that corporate director duties are to promote the value of the corporation for the benefit of firm-specific stockholders, not stockholders with their employee hat on, not stockholders as customers, not stockholders as community members, not stockholders with broader interests, as some have argued, nor are there duties owed to shareholders as diversified investors in a broad portfolio who therefore might also care about a broader range of interests. The fiduciary duties owed by directors of a Delaware corporation require them to maximize the value of the corporation over the long term for the benefit of stockholders as residual claimants, et cetera, full stop. Okay, so they rejected this kind of broader vision of what shareholders care about. PRC company law recently amended, many of you know, has long taken a kind of Chinese ambivalent approach towards shareholder privacy. There has always been a recognition of stakeholder interest in the company law that's been strengthened a little bit in the recent amendment. We've got a reference right in Article 1 about the purpose of the law, the company law amendment, being to regulate the organization and operation of companies, protecting the lawful rights and interests of companies, shareholders, employees, creditors, all in the interest of improving the broader economy. And there's always been a recognition in Chinese company law of the important role of corporations in society. And that kind of conversation is less central in the US context. Similarly, Article 20, which used to be Article 5, is kind of the article encouraging social responsibility. It's been tightened a little bit, and it says that a company shall fully consider the interests of a range of stakeholders, employees, consumers, other stakeholders, ecological, environmental protection, and the public welfare. So there's always been a recognition of the public role, again, that companies play in our society. So my paper, again, is looking at what's the impact of climate and sustainability disclosure regulation, which we're about to talk about, on all of this, on how we define good governance, on this debate, on the role of shareholders, and again, from a US context that is now, again, kind of doubled down in some ways on shareholder privacy. So as many of you may know, there's been a lot of movement in capital markets in the past 5 to 10 years, and particularly the last 2 to 3 years, particularly here in Asia, in Hong Kong, the International Sustainability Standards Board, or ISSB, reporting rules for climate will come into effect for listed companies in January. Singapore, same thing. The ISSB standards, which are kind of referenced first in that bullet point there, are being recognized as the global standard for reporting on climate and sustainability information, and in particular, climate governance information. And I'll say a little bit more about that in a moment. The EU has a much stricter regime, but it was developed in recognition that the ISSB was happening. And so those two systems are aligned. The European system is stronger, as we'll say and show you in a moment. And then the US itself actually went ahead, the SEC went ahead and, as many of you may know, has introduced climate disclosure reporting rules that are not aligned directly with the ISSB, but are built on the same foundation and are intended to be as close as possible in terms of alignment with the ISSB standards. They are currently being litigated. As many of you know, we litigate everything in the US, and these rules have become increasingly controversial. But nonetheless, they were adopted. We'll see what happens in the coming year when that case is decided. But all of these systems are based on the TCFD framework that was developed a number of years ago to deal with climate risk and the possible threat that climate change poses to the economy and to the financial position of our companies and our financial institutions, and in particular financial institutions. That was a direct focus of the TCFD framework project. And what you can see if you just look at the headings, I know there's a lot of text here for those of you that may be less comfortable than the students in reading in English, fine print, just don't worry about it. Look at the headings. These are all related to governance in some way, okay? Governance, strategy, risk management, and then metrics and targets to measure that. This whole framework that this reporting system is based on has to do with how do we account for risk and what is the role of the board and senior management and management processes in tracking that risk and monitoring it. So these are all governance concepts. Okay, China has recently announced this past year, a couple months ago, that it is moving to adopt or to align with the ISSB. This is from the Ministry of Finance. So, but the CSRC and a number of the stock exchanges have already introduced new sustainability disclosures for certain companies that are in recognition of and incorporate many of the elements of the ISSB and indeed that kind of 4-pillar framework from the TCFD. So globally, everyone's using the same kind of starting points, the same kind of framework, but tailoring it and adapting it a little bit to local circumstances. And certainly in China, that's been the case, but hopefully we'll see forward movement here in the mainland as well. So the question then of like, what does this have to do with corporate governance? One of the projects, one of the contributions I hope to make in this paper is first of all to just show that there's not one model. There are certainly common starting points, but we have models that range from what I'm going to call thin to thick corporate climate governance. And now we're finally getting to the title of the talk. What does corporate climate governance mean? That's a term that I've created, but I want to suggest it does not have just one meaning, because again, there are kind of narrower concepts and broader concepts. And one of the starting points is really built into these disclosure rules themselves. Okay, so some capital markets like the US, like Hong Kong, Singapore, like the mainland, like Hong Kong and Singapore, I should leave the mainland out, have adopted what we call a single materiality standpoint. And what that means is we are going to disclose only climate risk that affects the company itself. We are looking at risk from the company's standpoint, and we are including information that would be a risk financially or might be in the future. It might have a material impact in the future. Okay, so that's the lower kind of part of this slide, lower box. A double materiality concept, which is what the mainland regulators appear to be moving toward, and what Europe has adopted, includes not only climate risk as defined from the company's perspective, but as defined from the impact of the company on external stakeholders. So double materiality approach. That's what I'm calling a thick approach. So if you look at kind of the spectrum of governance matters, and I talk more about this in the paper, there's kind of, again, a spectrum of thin. No surprise, the US is on the thin side, all the way to the thickest or the most stringent, which is the EU standards, and the ISSB is somewhere in the middle, and that's intentional. Okay, so what would be a thin conception of corporate climate governance on the left? The thick conception includes everything on the left, as well as some additional factors on the right. So what would be a thin version of corporate climate governance? Okay, first of all, single materiality. We're only looking at governance and risk effects to the company itself that would affect it financially. Okay. The scope could also be thinner or thicker. We could just be looking at climate, or we could be looking more broadly, as the ISSB and the EU do, at climate plus sustainability. Okay, so Thin would be climate only. What are some of those governance requirements that are, I would submit, new? Okay, even in a thin regime, you have to assess, does climate matter? Does climate risk materially affect you financially? You have to look at it. You cannot ignore climate risk. Secondly, it is now elevated to the board level. All of these disclosure systems require you to say whether or not your board is doing something. In other words, the expectation is the board will be doing something. Okay, and the movement is to have board oversight of climate risks. You have to disclose. You can say we have no climate risk, but you have to directly say that. And you have to say you have made that determination. And you have to, for all of those reasons, involve or incorporate climate factors into decision-making at some level. You also have to monitor greenhouse gas emissions. Okay, so again, what I'm arguing is that stakeholder issues, if you think about environment and climate as more of a stakeholder or public-facing issue, are being brought into corporate governance. If we go to a thicker conception, you have to do more. You have to disclose that you're doing more. And by disclosing, you have to have put these systems in place. You have to have a corporate climate resilience plan. You have to be monitoring climate and sustainability impacts, either from a corporate perspective or an external perspective. You have to set progress toward climate targets and say whether you're meeting them or not. You have to have climate and sustainability factors integrated into risk management. And in addition, you have to at least say whether or not you are preventing and reducing those risk impacts on external stakeholders. So what difference does this make for corporate governance? Well, before we get there, let me just remind us very quickly of the critique of any incorporation or any attention to stakeholders within corporate governance. We are worried about several things. We are worried that it will give boards too much freedom to choose, too much discretion, and they will waste money or they will serve themselves. Agency costs will rise, and that's bad for the company and that's bad for investors. We are also worried, relatedly, that it will be inefficient. Okay, there will be ultimately no benefits, not just to shareholders, but it will not benefit or might harm stakeholders as well. We will get too much self-interest, right? And that there's no fair way, the concern is, to make trade-offs among the different stakeholders. As a result, it's impracticable and ultimately, again, value reducing. And if it's value reducing, it's not good for anyone. So that's kind of the core argument. Now, there's been a lot of writing pushing back on that. There will continue to be an active, robust academic debate, I am sure. Okay, but what I want to argue, and I'm going to close by just focusing on this slide and a couple kind of summary points, is that the introduction globally of these frameworks for disclosure, even though they do not apply to all companies, they only apply to listed companies, or in Europe, they might apply to large firms that are within scope. Okay, they do not apply to everyone. They do not purport to change company law, corporate governance rules. There's been some active debate on that. Okay, however, my argument is that it is not business as usual. There is an indirect corporate governance effect, and we might be seeing a transformation of how we define good corporate governance. In what dimension? So on the chart, I have some dimensions. I just want to talk about the red ones, okay? So if we talk about corporate purpose, we're moving from a focus on long-term shareholder wealth maximization to a more stakeholder integrated version of shareholder wealth, shareholder benefit, shareholder value, okay? And there's some terms on the left, or on the right rather, that refer to that. Long-term firm value optimization, the firm doing better, the corporation at the center, okay? Maybe more so than shareholders. What about agency costs, okay? In the past, we really only focused on two agency costs, two conflicts, shareholder management, majority minority. What about the third one? We've always known in the literature there is a third agency cost. There is a third trade-off, the shareholder-stakeholder trade-off. In the US and in US scholarship, we have largely disregarded that and said that's the job of government. That's the job of public law. That's not the job of private law. That's not the job of corporate law. It's really not the job of securities regulation either. Hence the litigation, okay? But today we're bringing that third conflict in and recognizing we need to engage with it. It's not easy, but we need to engage with it. What about risk oversight and risk management, which are core parts of the duty of care, of the best interest of the corporation, from a US doctrinal standpoint for you corporate law scholars and students, duty of loyalty, okay, corporate oversight, but it's something all boards need to do, right? Well, today they can't ignore climate. That is not within their discretion, okay? That used to be completely discretionary. I would argue these systems require you to adopt climate-bounded board discretion, okay? In the past, the main goal against which management was measured is to incentivize risk taking. How do we view risk? It's something you should be encouraged to take. That's why we have executive compensation systems that align with shareholder interests, right? We want you to think like a shareholder. We want you to take risks so that you'll make money, okay? We were not really worried about managing risks, measuring risks, mitigating risks, right? There are these certain kinds of risks, but now that has to be part of the conversation. We are now talking much more about risk management and mitigation. That's a different direction than just take more risks no matter what, because you're going to make money, right? That requires a different kind of thinking, okay? Board discretion and strategy, we've already said, cannot be climate blind any longer. I think that's kind of obvious from an economic standpoint. Profit sacrificing, this is the tricky part, okay? Corporate law says you're permitted to sacrifice profit if it is value enhancing or otherwise in the interest of shareholders, at least from a US perspective. Under these systems, and maybe under the real world as we live in it going forward, we may be required to trade off profit in some ways, to preserve assets, to manage risk, or to meet some greenhouse gas or resilience targets. What does that mean in different jurisdictions? Is it permitted? Is it encouraged? I mean, I think this really is a corporate law and a corporate governance question. To what extent are directors able to behave in this kind of new way that we are asking them to as a matter of climate adaptation? So the paper, to be honest, I'm looking forward to your feedback because I'm planning to split it into two papers. This sometimes happens to us as we do research. Even by US standards, my article, if you attempt to read it, is far too long, I think, for the average reader of a US law review article, which means it needs to be two papers. So the first paper will be the thin and thick spectrum. What does this mean for corporate governance from a US standpoint in terms of doctrine, in terms of how we think about that chart I put up a moment ago. But the second paper will be more engaging with this broad shareholder stakeholder debate and the critics of stakeholderism. So from the first part, the first paper, my main argument is that this thin version of corporate climate governance does more than we think. So even if the US only adopts the US disclosure rules that say almost nothing about corporate governance, it still will have an effect on corporate governance. I think that thin corporate climate governance really does matter because it requires integrating climate, integrating certain stakeholder considerations into decision-making, requiring companies to think consciously about these factors when adopting corporate strategy. Is this a transformation of corporate governance? I don't know. I will leave it to you. We will see. But I argue that the thin version still matters and is still somewhat radical. Okay. With regard to the second paper, or the back end of this paper, there is a great fear of the thick version, at least from a US perspective, for all the reasons that we have discussed. It is a long-standing debate. We know what the concerns are. Okay. We know the trade-offs could be real. I am arguing that the thick version of corporate climate governance is less transformative than we may fear, than we may be afraid of. I argue in the back end of the paper that these thick systems, if we look at the EU system, I don't have time today to go through it, but there are many aspects of the EU system that prevent some of the downsides of an open-ended, fully discretionary, stakeholder, ESG can be whatever you want, kind of corporate governance system. Okay, there are real measures, there are real constraints, there are real priorities that are set. And one very interesting feature I will take time to highlight of the EU rules, for those of you that are interested, is that, second from the bottom, if you disclose that your response to climate and your climate mitigation strategy will require you to lay off workers, for example, or to reduce compensation or not, raise compensation over the long term. There's a trade-off there. You have to disclose it, and you have to say, what are you doing to reduce it or manage it? It is no longer hidden. It is no longer up to you. You have to be transparent about what you're doing. Meanwhile, let us not forget that the introduction of these systems does not eliminate everything else we already have in the law to deal with self-interest, conflicts of interest, majority versus minority conflict. That law is untouched and unchanged. Creditor protections, all of that is still in place. I don't think we're headed to what we call in the US a wild west of corporate governance, even if we were to adopt a much thicker European leaning kind of system. And maybe that's something for those of you here in mainland and for us in Hong Kong now to think about. I think there's a lot more scope for innovation and imagination. So I am at the end of my time. I will stop there. If you're interested in the paper, it's on SSRN, but I welcome your comments.
Hey, thank you very much, Professor Harper Ho.